The body cam audio starts mid-sentence. Delete the video frame. Unlock the phone and delete it now. The dash cam catches the officer's hand dipping toward the driver's window, red and blue light, and crawling across wet pavement. The driver's phone is still recording pointed at the center console, not at the officer's face. Those words, on the side of the road. The next 10 seconds can either preserve the only impartial witness you have or turn a traffic stop into an obstruction arrest. I've spent more than 2 decades in criminal defense, and I can tell you this is not a question of officer opinion. It is a question of constitutional limits. Let me set the scene as a composite story drawn from body cam. Patters, not a real named person. A driver gets pulled over for a license plate light at 11:15 p.m. He places his phone on the dashboard with the camera rolling. When the officer reaches the driver's window, ask them to make the following statement. Window. The carding the window. The driver says, "I'm just recording for both our protection," and the officer's eyes go to the screen. Turn it off and delete that route. You don't have my permission to film me. The driver doesn't. The officer says. Then you're obstructing. First thing you need to understand, no law gives a police officer the power to order you to erase video from your own phone. Not a statute, not a department policy, not a roadside demand. And erasing that footage would mean destroying evidence. Courts do not hand officers a delete button. If anything, the law runs the opposite direction. The moment that recording captures police conduct, it may be evidence in a civil rights case, a criminal case, or an internal affairs investigation. An officer who tells you to delete it is not telling you what the law requires. He is telling you what he wants. And the reason you can stand there recording is the First Amendment federal appellate courts have repeatedly recognized a right to record police officers performing their official duties in public. In Glick v. Cuniff, the First Circuit threw out a prosecution against a man arrested for using his phone to film officers making an arrest on Boston Common. The court called the right to film police in public spaces a basic, vital, and well-established liberty, safeguarded by the First Amendment. And other circuits have said the same thing. In Fields v. City of Philadelphia, the Third Circuit held that officers violated clearly established First Amendment rights by arresting 2 onlookers who recorded police making arrests during a protest. And the fact that the officers found it annoying did not make it a crime. That right is not unlimited. You cannot shove the phone into an officer's face, physically interfere with an arrest, cross a police line, or use the camera to harass someone. But standing at a reasonable distance with the camera rolling is not a crime. One more piece of this puzzle. Officers sometimes say, "This is an active investigation, so turn it off." There is no general investigation exception that cancels the First Amendment. Police can order you to move back to stay behind a line, to stop physically interfering. They cannot order you to stop recording simply because they do not want a witness. The only time recording becomes a problem is when it physically obstructs them or violates a valid, narrowly tailored restriction. And deletion is not a restriction, it is erasure. Now the officer may pivot to, "Give me the phone." That is a different legal question. Under the Fourth Amendment, your phone is not just a camera. In that police generally cannot search a cell phone without a warrant. That case matters here. A phone is not. Can police seize the phone itself? It's to believe it contains evidence of a crime, and there is a risk that evidence will be destroyed. Is completely different from ordering you to delete. The other destroys it. The rest of its contents still generally requires a warrant under the threat you will actually hear on body cam. Refusing to delete a video is not obstruction. Physical resistance. Giving a false name. An investigation pie. It does not. In City of Houston v. Hill, that made it a crime, holding that the First Amendment protects to police action day. You do not, but simply saying, I'm not deleting that. So what do you actually say? I want you to remember, are built around property. I am not deleting anything. I do not consent to you taking my phone. Am I free to go? Or am I? That one sentence does three things. It objects to a seizure before one happens. State whether you are being detained or if I am free to leave, which matters if this later becomes a constitutional action. You are detained. You keep your hands visible and you say one more thing. I'd like a supervisor and I want this documented about the facts. Note, I do not consent to a search. Asks to look inside your car or pockets, but the legal issue in this moment is, so the phrase targets seizure, not. You have the right to remain silent, but choosing to speak for the body cam high. If the officer grabs the phone, do not fiction over a phone will always end with you in handcuffs. Your remedy is not in the moment. A civil rights lawsuit or an internal affairs complaint later. Take the phone if he is going to. Just keep repeats about not consenting. Ask for a supervisor if you can. One warning I have to give you. You to delete footage yourself. Told you to, you are not necessarily committing a crime in a criminal investigation and, work in a very different kind of trouble. The safest position, refuse consent to seizure and preserve the footage. If an officer says, delete it, is not a lawful order, but say your phrase, ask for a supervisor, exercise your Fifth Amendment right. That is not admission of guilt. Back to the body cam in our composite stop, the driver says the exact phrase, hi there. The officer repeats, I'm not asking. I'm not deleting anything. The officer stands there for a long moment, then says, the video survives. That is not a movie ending. It happens all the time. They push the deletion issue. But if they push anyway, First Amendment for the and no obstruction in a simple refusal. Wait until we get into what and suddenly calls an inventory search. That furry stalkshiness. That one ever will.